Now, all these provisions to cause a harm to someone, including the right to cause a death of B, it could vest in A. All these falls under the general exceptions which are carved out in chapter Roman 4, Roman IV of our Indian Penal Code, IV, Roman IV. And in that, the real sections are there, which starts with section 92. I'll put it in this way. 96. Things done in private defense. I will have to read because this is I'm not teaching you with a blackboard and any other aid at my disposal. So you will have to have some patience in my reading. Section 96 deals with the things done in private defense. Nothing is an offense which is done in the exercise of a right of private defense. Section 97, right of private defense of a body and of property. Every person has a right subject to restrictions. Mind this word, subject to restrictions, contained in section 99. Now I am reading 97, 99, 9 comes later on, to defend, first of all, his own body, that is his personal own body, the body of another person against any offense affecting the human body. Secondly, the property, whatever the movable, immovable, himself or of any other person, any act which is an offense falling under the definition of theft, robbery, mischief, criminal trespass, which is an attempt, fantastic, which is an attempt to commit theft, robbery, mischief in criminal trespass, fantastic. Then comes your right of private defense against of unsound mind. Then important thing is the act done against which there is no right of private defense, that is also incorporated, extent to which the right can be incorporated. And the most important is the right of a private defense of a body which extends to the causing of the death also. So this is something which permits A even to the going to the extent of causing the death of B if B endangers the life of A with arms, without arms, or whatever, with any other article, iron rod, etc., etc. Now, most important thing, that this right is section 100 is not exercised or used only by the police officers. A is a common man. Even A, though he is not a police officer, though he is not a public servant, but even his right, if he feels that B is going to cause such an act, I overpower B, including harming him to any extent, knowing fully well that it can result in his death also, it can endanger his life also, then act done by A of causing death of B cannot be treated as any other offense for which the person is normally tried under section 302 of IPC. So these are the basic foundations of the right of private defense. These are the exceptions which have been carved out in chapter 4 of the IPC, which you must be very well aware of, and on the basis of which only, this is the defense which is normally taken by the police fraternity whenever they claim that we were required to liquidate a person who was supposedly a criminal, supposedly armed with some weapons, etc., etc. It could be arms, weapons, or it could be anything else. And therefore, this is the section 100 is the only recourse taken by the police officers whenever they use this right of self-defense. Now our reading part is over. Now what I will do, I will give two very important examples we discussed throughout the country for the last 6 months or so. Many of you will recollect that in the December preceding year 2019, we all heard that one female veterinary doctor, she was returning from the hospital to home on a scooter, and in the process she was chased by for some rogue villains. Then after a certain time she does inform her brother that somebody chasing me, some goons are there apparently, and her brother is believed to have communicated to the control room or so, and unfortunately instead of coming to his rescue, the control room people are believed to have told him that is it a right time for your sister to come alone and all that? So the control room people started giving him the pep talk rather than addressing his immediate necessities or urgency for that matter. And that is how he was left in lurch. Later on, this lady was chased. She was overpowered by those four goons. She was taken to some near under bridge and all that. Unfortunately, she was gang raped. She was murdered, and her body was mutilated, and her body was thrown. Incident of a female veterinary doctor from Telangana near Hyderabad had created a huge uproar throughout the country. Condemnation of highest kind took place. It became a very national news also. All news channels throughout the world, CNN, BBC and all that, they started flashing it and all that. There was a huge uproar. And finally, with, I should say, great difficulty also, police could come to know the whereabouts those four persons who were just trying to escape from one place to another. They were attempt to hide from one place to another. They were caught. They were produced before the magistrate. Their PCR police custody, and subsequently, they were, after their police remand was over, maximum 14 days under the Indian CRPC section 167. That is the section under which the remand is obtained by the police officer of any culprit, any accused for that matter. So after 14 days expiry, the accused is transported to the magistrate custody, which is also called a judicial custody. And once it goes to the judicial custody, that is a prison. There is a different prison administration. Every state is having its own prison. Provisions are almost identical, but depending upon the topography and the area, I mean, this state and all that, many minor things changes could be here and there, but most 99% provisions are almost uniform in all the prisons of our countries. Now, when they were in the judicial custody, they were in the magistrate custody. Police claimed, concerned police who were seized with that investigation of that offense, they claimed that they wanted to reconstruct the incident of that alleged incidents of abduction, kidnapping, rape, murder, and throwing over or trying to hide her body or whatever. Now, when the original incidents has happened in the month of December in the evening, you can in December or so, what is the light condition is there? The light is usually, even at 7 p.m. also you can see some sunlight here and there. So it's not totally dark at that time. Whereas they wanted to reconstruct the event of that alleged incidents of kidnapping and so forth at 3 a.m. Now, what can be the light at 7 p.m. and what can be the situation of light at 3 a.m.? These are not congruent at all. So how can you take at 3 a.m. in the morning? Now, police theory came that we took them away to reconstruction of the scene, and we were taking those four culprits. They were absolutely thin. They were not a hefty fellow. They can't be called as a gunda at all. Presumably, they had no criminal record also. With one slap, even one could have asked a cup of water. I mean, one could have a glass of water, he could have demanded. So they were so thin, not able-bodied also, you can say so. They were hardly in their teens and 20 plus like that. So, unfortunately, as there was huge uproar throughout the country, it became very intolerable for the AP police to cover up their, to get out of these allegations and all that. Presumably, they decided to get rid of those four persons, and under the garb or the pretext, I should use the word, of reconstructing that scene, they were taken out of that prison. Mind well, there was no specific permission or the order of the concerned magistrate in whose judicial custody they were. You can't take out any person who is inside the prison, who is always under the control and command of magistrate, the MFC. You can't take him out. So no such order specifically in black and white was obtained. They were taken out, and under the pretext that they attempted to flee, they tried to snatch the whatever the arms, pistols, revolvers or guns the police party was having, and in their attempt to overpower the police, in their attempt to kill the police officers, they were liquidated or they were killed in supposedly an encounter. And once that news got flashed throughout the country, there was a huge sigh of relief. Everybody were happy. Rightly or wrongly, that is a matter of debate. any for law-abiding citizen, it was wrong jubilation, because that such kind of encounter cannot be endorsed. But many people felt that in Nirbhaya's matter, when the incident had taken place on 15 December 2012 or so, the accused came to be finally hung up during this lockdown in 2020, May month or April, I should say. They got hanged ultimately after exhausting all due processes of law after a gap of 6 to 7 years. So after this Hyderabad incident, they were starting saying that had they been tried as per the regular procedure of law, then probably by 2027 or 2029, by that time they would have grown up substantially. Things situation would have changed everywhere throughout the country and all that. People's memory is very short. Then they would have been hanged up after all remedies have been exhausted, Supreme Court and presidential pardon, etc. So therefore, there was a jubilation on the part of some element. There was a condemnation by those who were believing in the democracy or the judicial process, like we do as lawyers. And that is how the encounter story rests there. Then just a couple of weeks back, all of us heard that a very Namchin Gunda called Vikas Dubey, who had a series of offences against him in the Uttar Pradesh, more so in the Kanpur and Chaubepur, the precise name of that police station where he was operating in that area. And presumably he was having in the connections with the police department too. But something happened on the night of 2nd and 3rd July, intervening night of 2nd and 3rd morning, that when police party attempted to went to his play, I mean, hold of him, post midnight, he got wind of it, and he and his associate, they had temerity of exchanging the fires with the police, as a result of which 8 police officers got killed, including a DYSP. Now that is bound to cause a huge uproar and consternation throughout the country, that a criminal is killing 9 police personnel, including one a DYSP rank officer. That became a very big news, again international news, so on and so forth. And then within 24 or I should say 36 hours or so, the house from which he, on the top of it, he exchanged fire with the police and police got killed. That house came to be demolished. Now, I don't want to engage into debate at this juncture whether that demolition of his house, under whose orders and for what purpose, that is a separate matter of debate. But after killing them, he ran away. Then some people say some footage was available on television channels that he was seen in Faridabad, so on and so forth. And all of a sudden, on one particular day, he came to have surfaced in the city of Ujjain at Mahakaleshwar temple. As a simple disciple, he makes an entry. He goes through the security cordon and all that. He's seen with some thaili with him. Then he enters one corridor, another corridor, so on and so forth. And one security guard happened to have witnessed him, and as his picture was getting flashed for the last 2-3 days, one could have in his memory the nature of that particular, I mean, snap or the facial description of that particular Vikas Dubey. So when private security got a wind of it, that possibly he could be the person, Vikas Dubey, who has come to our temple complex. So he alerted one lady police officer over there, and she was also very wise enough not to immediately arrest him. She was keeping track of his movements, how he's going and all that. She in turn informed her superiors and all that. Then police party came, and subsequently he was caught. And we had seen on the television channels when he was being taken to a police jeep, he said, Vikas Dubey Kanpur wala, that the statement became very famous. So that is how he was arrested. That again became a news on the one particular morning around 10 o'clock or so. And later on, Uttar Pradesh police on the same day evening came to Ujjain for the purpose of taking him back to Kanpur, where the original offense of killing the police officers 302 was obviously lodged on the 3rd of morning. And when they were taking him back to Uttar Pradesh, MP is one state, UP is another state. Any new lawyer also will also tell you, accused from custody of one state of police, and when his presence is sought or his custody is required by the police of another state, any prudent police officer will take his transit remand. So moments of that particular accused from place A to place B in another state, that become legal moment, that custody also becomes a legal and valid custody, irrespective of the timing of the journey, because under the CRPC and police manuals, police rules and all that, police can detain any person only for a period, technically speaking, only for a period of 23 hours and 59 minutes. Suppose, meaning thereby that if the police require custody of any accused for the investigation of any crime, then if his detention is required for more than 24 hours for interrogation, for recovery of certain things and all that, confronting him with some other accused or some witnesses, etc. In that case, police are required to take his custodial remand, authorization of his custody through the magistrate, that is called obtaining the police custody remand. Now, in this case, no doubt it was not necessary of 24 hours. It was, some people say it was 16 hours or so, whatever. But when you arrest somebody from in another state, you take back to his home state, is that thing it should have been done, transit remand. And when such accused is produced before the magistrate of the Ujjain court, Ujjain JMFC, the name of the magistrate Tukri Pandey was also, it had come into news at that time that he will be produced before her and all that. But that was not done because no police officer can produce an accused with any weapon on his person or on his body, because he was unarmed when he entered into the temple. So the question of him possessing any revolver, license, katta, gauti and all that, license or unlicensed, whatever, legal or illegal arm, that doesn't arise. So when his police custody was not obtained and he was being taken from Ujjain to Kanpur back home, on the following day morning, under the pretext, the theory that is coming out is that the vehicle turned turtle, that particular vehicle. And when that vehicle got turtled, it became motionless. He attempted to flee. And when they had an exchange of fire, he attempted to overpower the police. He wanted to get away from their custody and all that. And in that process, he took up the arm from some police constable or police party, or it was a special task force. So they must be equipped with a very heavy kind of weapons and machinery, I should say. But it did happen that this theory came out that he attempted to flee police. There was an exchange of fires, and in the process he got eliminated. Now, mind well, the convoy of the police vehicle, special task force, STF, some 10 to 12 vehicles were there. They all went from Ujjain to Kanpur, and they were going as if it was a procession. It was like a caravan with some distance between all the vehicles. Now, if one vehicle gets turtled all of a sudden, then the subsequent vehicle behind it is also supposed to dash off that vehicle, because all are in the huge speed. So if the vehicle in front of me gets turtled, it gets stopped, it gets halted. If I am in the subsequent vehicle, the vehicle next behind that vehicle, then I'm going to dash off that particular vehicle. It didn't happen. Moreover, when the electronic media made a very excellent work, that he was supposedly placed in vehicle of some Tata make, and a vehicle that actually turned turtle was of Mahindra, something of that sort. So vehicle mark A or make A, in which he was placed in at Ujjain, but the vehicle was vehicle of mark or make B. And 10 minutes prior to that scene of offense, all the media was asked to halt. They were forcibly, had only sent a feeling to the media that something untoward is likely to happen. And that is how the suspicion grew up. And finally, it was announced that he was dead. He was required to be killed because he tried to endanger the lives of the Qaidi party or the STF, who were sent to Kanpur. Now, even the Supreme Court felt there was huge uproar in the media also, and everybody said that this is absolutely fake encounter. It can't be like that. STF are well armed, well equipped, hefty police officers. How and even Vikas Dubey also for that matter, just like the Andhra Pradesh, those Telangana accused. He was also ordinary, simple physique man. He was not a robust. He was not a hefty 6 feet tall and 100 kgs in the weight and all that. He was an ordinary looking man. So the question of he overpowering STF doesn't arise at all. So even the Supreme Court sensed something fishy in that. As a result of which, our Chief Justice Sharad Bobde has appointed a team. A committee has been set up, led by former Supreme Court Justice Ganesh Sovani, who was incidentally Chief Justice in our Mumbai High Court also. in 2006 or 7. Then when KL Gupta, DGP of Uttar Pradesh, is also part of the team. Now that entire team will be looking after the incident, how it took place and all that. It will sift the papers and all that. That within 4 weeks time, that committee is supposed to come out with its finding whether the encounter was genuine or otherwise, etc. I mean, it was a fake. Then depending upon the report that will bench of court number 1 of Chief Justice, because he has taken the cognizance of this incident. Then future course of action, future orders, or even including the prosecution of the police party which has supposedly liquidated him and all that, that will take place. So these are the two incidents. After giving you the initial background of what, theoretical background I should say, what constitutes a right of self-defense, which is covered from section 96 and it ends up with 100. Now, as I said in the beginning, many a times encounters often create controversies. You can notice that there is always a uniform pattern in all such encounters. Very, very uniform pattern. 9 out of 10 encounters takes place after sunset or before the dawn. So after sunset, from 7 p.m. onwards till 6 a.m. in the morning when it is a dark. Another notable feature of this is this, that there is no independent witness to such encounters. Means the only possible witness could be the other members of the police party who have not physically participated in an encounter. So if at all only one armed officer has used his revolver or a pistol for liquidating the particular criminal, one criminal or two criminals for that matter, or two officers are there having arms and they're liquidating or they are carrying out the encounter of two accused or more than one plus, I should say. So apart from police party, there are no independent witnesses who can vouch or who can justify or who can endorse the police contention that because their lives got endangered, this particular police party had no option but to use their arms and liquidate or cause an encounter of that person from whom the threat had emanated. The person who is liquidated has to be an aggressor as per the law. Various judgments are there, provisions are there. He has to be an aggressor, number one. His aggression should be sufficient enough to cause a fear in the mind of the police party or police personnel, if he's individual, that his aggression is going to threaten my own life, and if I have to overpower that aggression, then I have no option but utilize my arm, my revolver or my pistol, which is there with me. Being a police officer, it's a legal arm. I'm carrying it legally, and therefore I have no option but to liquidate him, or to, the only way to overpower him is to kill him. So that is the normal defense which is always taken by the police person. Now mind well that whenever such encounters takes place, always an FIR, First Information Report under section 154 of CRPC is given by the police party at its own police station, or unless it is a crime branch, then crime branch will go to the concerned police station within whose jurisdiction that offence has taken place, and that FIR will be lodged. Now, against whom it is lodged? It is lodged against a person who has been liquidated by them under this grievance or this allegation, that person to whom we have killed, he attempted to kill us. Now, to cause the murder is 302, and to attempt to commit a murder is 307. So the person who is dead is implicated as an accused in a CR, crime register number, by invoking section 307 of IPC, plus always some weapon is required to be shown that he was carrying, because simply with bare hands, no person, no B with bare hands can endanger the life of A. So A has to have some weapon with him. B has to have some weapon with him to show that because of that particular weapon which he was carrying, it endangered the life of A, police personnel. So some pistol or some revolver, obviously it is illegal. Gauthi katta of that sort is shown on his person, that when he died in the pool of blood, that revolver was found with him. Now, mind well, the 307 is registered against. It is also most of the time shown that he was also accompanied by one or two whose identities are not revealed, and therefore 307 stands registered with a dead man under 307 plus his two accomplices, Ani Itar. In Marathi, what we write, Ani Itar or do log. Then the investigation proceeds. Now, the investigation party, the offense is, that CR is interested. In olden days, before the National Human Rights Commission into existence, and it laid down the guidelines in 2011. Now, they have given the modalities it should be used while investigating all encounter-related offenses. Now, before that modalities were drawn or came into force, I will just tell you the background. So, if I'm in Thane city, I'm in Thane, any encounter takes place in Nopada police station, police liquidate someone, then that offense will be registered by that police party at Nopada police station. Or even assuming the police personnel who were at night patrolling, they found some suspicious movements of some person in Thane town area, Thane Nagar area, or Wagle estate, or say Kopri and all that. Ground in their own jurisdiction, but for some purpose, they have gone to find out someone else. They have gone in the jurisdiction of another police station. From A, they have gone to B. Then the jurisdiction in whose jurisdiction the offense has taken place, they'll have to register the offense of 307 against the dead person over there. Then the IO will be appointed by the senior PA of that police station. He will go to the spot. Panchanama will be done. The man is dead, so in case Panchanama, body Panchanama will be done with the help of two persons. Then his body will be sent to the postmortem to the civil hospital. Then the doctor and his associate, they will carry out the PM. Viscera will be taken. It will be sent to Santa Cruz for the forensic investigation, so on and so forth. Then charge sheet will be laid, but it will be against whom? I won't use the word charge sheet. It will be a report, because dead man cannot be prosecuted. But when the National Human Rights realize that majority of the encounters are fake, they decided that the investigation of such kind of offenses should be strictly done by the CBCID. What is CBCID? CB is crime branch, CID. So it is other than the police. They are police only, but they are not wearing khaki. It's a separate department card out in every police establishment. In commissionerate area, there is a crime branch, and in rural areas we are having local crime branch, LCB. That is called LCB in local district-wise areas. Now, then the investigation is done. So to ensure the neutrality in the investigation, NHRC recommended that it should be better entrusted to the CBCI. So NHRC has said postmortem should be videographed. The manner in which the doctor will be engaged when the postmortem is required to be done, like a hacksaw. You know hacksaw, what we call in Marathi as a karvat. That hacksaw is virtually used in bisecting the body right from the top, and this skull is separated, everything is separated, then viscera is taken out, then the viscera forensic examination, etc. So all this entire process of post-mortem is required to be videographed, concerned medical officer of the civil hospital, and then the report is then subsequently sent to the police by the RMO, and that becomes a part of the charge. Now, I will be citing you certain examples in the course of, and two examples are very famous. They are from, and well, in 1990s, our city of Mumbai had witnessed a lot of extortion related cases. Somebody used to phone a very rich and high profile person and say that I am so and so RB bol raha hu. if you want to carry on your life and business well, you'll have to give the beauty of so and so to please my boss. So that is how phones used to come from many places like Dubai, Abu Dhabi, and Malaysia, Singapore, Australia, Hong Kong, so on and so forth. So in the name of gang lords, so these phones were used to be done by their local agents or local elements. And that is how the extortion used to take place. Then the person who is threatened, he had no option to save his own life. He had no option but to pay that ransom, whatever the money was demanded and all that. But that became too much. And as a result of which, to overcome this menace of extortion related things, encounters, raids took place. But at the same time, our then Maharashtra government, they had promulgated Maharashtra Organized Crime Control Act, what we call as a MACOCA in the local parlance. Now, I know that my lecture is strictly confined to encounters, but in the process, I was required to mention this because MACOCA and extortion, they go virtually hand in hand. Now, this extortion related things and the encounters, they became so rampant that I'm having a statistics that from 1991 to 1995, as many as 135 different encounters had taken place in and around city of Mumbai, or even for that matter, you can incorporate Pune or Nasik in that. So in Maharashtra, you can say so. So the gap of 4 years, 100 plus encounters are taking place, which is a very tall order. And a lot of doubts were expressed by the persons whose kins were eliminated, their relations got eliminated, somebody's brothers, somebody's fathers, uncle, so on and so forth. Then they disputed these encounters. They approached the Human Rights Commission. They approached the National Human Rights Commission. Some of them even also went to the approaching the Honorable High Court. After the lower court, magistrate court did not entertain their private complaints, they attempted to lodge by invoking section 1563 of CRPC, because that provision is applicable in cases of those complaints or the complainants whose complaint or is FIR is not taken in ordinary course of business. So if somebody goes to police station with an allegation that, look, so and so offense has taken place either with respect to me or with respect to someone, and this is my offense and this is my complaint, so kindly convert this complaint or kindly convert my written application into an FIR. But when the police, they refuse to note down an FIR and they say, no, this is only cognizable or this is a civil dispute or whatever, then the complainant has no option but to take recourse to JMFC. And 1563 complaint is lodged before the magistrate, then the magistrate directs the police to take down an FIR. Which could have come in the ordinary course of business is finally taken at the order given by the concerned magistrate. Now, in one particular matter, which I am going to tell you of Warsaw police station, there was one A who was having business relations with Mr. B. I don't want to name them. Case laws are there. They have been cited. The case law which you have to follow in this case is of Prakash Kadam, Prakash Kadam versus Ram Prasad, AIR 2011-1945. This you note down. AIR 2011-1945. Markandeya Arjun Justice Ganesh Sovani Mishra. It is in case of Prakash Kadam. He was a police personnel who was present at the time of encounter with the police party, which had liquidated one person, Mr. A. And Ram Prasad Gupta is the one whose brother in fact came to be liquidated. So this is the citation you have to follow. So in this matter, A and B, they were having some business relations. That business relation got spoiled and they become more and more bitter. They became foes once they were friends once upon a time. And that enmity between them grew up so much that B could not tolerate the existence of A, and therefore B decided to hatch a conspiracy. Conspiracy is a typical word in the section 120B of IPCs pertaining to conspiracy only. So that B hatched a conspiracy with his police friends and all that, and they decided to liquidate A. So they were keeping track or trail of A. when they were keeping track, or one day they noticed that A is in the Washi area with his friend, some shopping or some meeting with some people and all that. So A and his friend both got kidnapped by that police party who were obviously in plain clothes. And that A and his friend, they were placed in Toyota Innova car. Now, they were placed in that vehicle, Toyota vehicle, from Washi. They came to Bandung. In Bandung, some more police personnel and some non-police, along with the police, they had brought some another kind of vehicle. So the person who was accompanying A was put into that second vehicle, and both the vehicles went towards Warsaw through Powai and all that. After reaching Warsaw, as per the brother of the deceased A, I am using the word very carefully, deceased brother, that A was taken to a place called Nananani Park in Warsaw. I happened to have seen it for many times because my some relations were staying there at that time. And it is a oval shaped Nananani Park, most of them, because these are used as a walking area for morning walkers and evening walkers. And police claimed that we noticed the moments of A. In fact, A had no crime record as such. So if A had a no crime record, A was not declared as a criminal, he was not figuring in the FIR. The question of police party in search of A, and that they notice his movements in behind some bushes and trees at Nananani Park doesn't arise. Nobody is required, no police station in Mumbai is requiring A for that matter. Then the police party claimed that we asked him to surrender. He refused to obey our orders. And on the top of that, instead of surrendering, he took out his weapon and he attempted to shoot us, our police party. And therefore, to overpower him, we had no option but to liquidate him. That is how the defense came, the version came from the police party. By that time, his accompanying friend was at police station only. So Prakash Kadam happened to be one of the person who was present at the scene of offense of the liquidation of A. And he, along with the entire police party, was booked in an FIR which came to be lodged by the brother of deceased A. And an order of lodging of FIR was required to be obtained only after approaching the Honorable Bombay High Court. So it was a High Court directed FIR taken against the police personnel at the instance of the brother of the deceased. So when that FIR came to be registered, that resulted into the arrest of police personnel. All details are excellently given in that judgment. And after a passage of time, some of the police personnel of various ranks, or in the hierarchy, there are various ranks out there. So some of the police personnel, they were granted bail by the lower courts. That grant of bail was challenged in the High Court, that though this police personnel who were forming the part of the police, or I should say, attacking party, though there only one personnel had utilized the arms while liquidating that A. So the use of arms, when ultimately the charges are framed, it is the main police officer who had shoot the A. He will be attracting 3 jurors. Others are accomplices. They could have very well prevented it, that, sir, you are doing wrong thing which is not permissible under the law. That is it. What that is was precisely the ratio that is laid down in the judgment, which I will be reading shortly. So nothing of that sort happened, but some of the policemen who were not actually physically participating in the liquidating that A, they were granted bail, whose grant of bail was challenged in High Court, and subsequently matter went to the Supreme Court. Now Justice Kadzu, while laying down the ratio in this matter, has made very strong observations about the police party, and he has said that we have no right to liquidate anybody without any genuine provocation from the person who finally stands liquidated. And Justice Kadzu had also said that if any police officer, any police personnel, I'm using the word personnel, it includes constable also and officers also, who is given command by his superior to carry out any illegal act. That illegal act is of any nature. The act which is not permissible under the law is an illegal act. It could be an illegal act under the IPC, which is an offense under the IPC, or it could be illegal act under any other minor laws also there in existence. So, such order is given by the senior officers to a inferior officer, someone who is below the rank of him. Then such junior level officer, junior police personnel should away refuse to obey these orders, which are illegal per se, blatantly illegal, and they should be reported to the higher ups. But it is okay theoretically to say so. In reality, it doesn't happen. A lot of obligations are there, a lot of things are there which cannot be discussed over here in such a short span. That sometimes it is impossible for the junior level officers to not to refuse the orders, and they are required to do not necessarily such orders of killing only, but any other illegal activity also. That just ignores somebody is carrying on the matka activity, some den of gambling and all that. If anywhere some prostitution or brothel is going on, just to ignore it, because somebody is interested in continuance in that particular illegal profession, so on and so forth. So Justice Kajju's judgment essentially says that lower rank officers, lower rank police personnel should strictly refuse to obey the orders of superior officers if the orders are patently illegal per se, I should say. Then another important ratio is laid down. That Justice Kajju and Justice Gyansuda Mishra have observed in that matter. Though, remember, Supreme Court was only seized with the matter pertaining to the cancellation of the bail. Supreme Court was not seized of a criminal appeal in which the conviction of the accused has taken place in the trial court. That conviction has been endorsed by the Superior Court, that is High Court. And finally, as a last resort, the accused party has gone to the Supreme Court by way of filing a special leave SLP criminal, that after its admission, it becomes criminal appeal in Supreme Court as per the rules of the Supreme Court. And then subsequently, been seized with the criminal appeal. But that is not the case. This was purely a criminal. This is so blatantly act of murder committed by concerned police. His names are reflected in that judgment, which I have cited, that nothing short of death sentences will be sufficient for such police personnel. Remember that Article 21 of the Constitution of India gives a right to every citizen, right to live and right of liberty. Nobody can take off the life of that such person without the due process of law. Even when the police personnel are aware that a particular person's movements are detrimental to the society, he is endangering the life of the society, though Section 96 to 100 empowers the use of self-defense, unless there is a grave provocation from that person, even police cannot liquidate him. Now, I began this presentation by saying that after the 4 culprits of Andhra Pradesh veterinary doctor, they were killed in an encounter, there was a celebration in certain segments of the society. Now, in response to that, police often come with a theory that had these not 4 men been killed, that could have taken perhaps 6-7 years or a decade also to put them on trial, one court, trial court, judgments coming after 3-4 years, then going into High Court, then there's a Supreme Court also, then presidential reference is also there, pardon is also sought. Then many times, even after pardon, as you witness in Nirbhaya case, accused used to again go to the Delhi High Court under one pretext or the other. So this is an unending process. So even many people who defended the police action of liquidation of the 4 culprits in Hyderabad encounter, they say that this is a quick justice. Immediately they were liquidated. So justice in haste, in a way. But that is not a way. We are in the democracy. We are governed by certain principles, certain laws are there. Constitution is there, CRPC is there, procedure is there, all the actions of the human being, actions and non-actions, act of commission and act of are all covered under the IPC and other minor law also. So in democracy, nobody has the right to liquidate the life of any other one except the procedure which is duly established by law. So that is Justice Kajul's judgment is very, very alarming. I mean, in fact, it's a warning signal to the police fraternity, the police machinery. And even when even police personnel who are watching this today's present webinar, they will also agree with me that once any police officer is embroiled in any encounter related an offense, when he's made as an accused, he faces the prosecution nothing other than 302 police personnel and his entire team. I'm handling one matter of 2000 which took place at Manikpur when police party was allegedly threatened by some dacoits who wanted to rob the cash from the petrol pump. At wee hours, again at wee hours at 5:30 in the morning, it was challenged by that culprit, and to overcome that, he was liquidated. And that matter, after a gap of 20 years, it is still lying in the Bombay High Court. And that Bombay High Court proceeding is just nothing but a criminal revision application and one or two repetition perhaps. But the main matter is still lying before the additional session judge was saying the main offense. And in that offense, Manipur police personnel and the police personnel of local crime branch Thane, they were made accused when the deceased person's relations, they approached the Bombay High Court. Bombay High Court in turn directed FIR should be lodged against the police party which liquidated that particular person, and that investigation was given to the CID crime whose headquarters is at Pune, what we call CID crime investigation department. Charge sheet was laid, and on some minor order, discharge related orders, the matter has gone to the High Court. For last 20 years, we are just taking dates and dates and dates. Once the matter is disposed of in High Court in whichever way, then the main trial will start. The incidence of 1999, even if the trial is to take now, it will be after a gap of 20 years. Many of the officers have retired. One of them, main accused, has died unfortunately after a passage of time. So what purpose is going to serve by causing such incident? That is what people are asking. So the encounter is not a solution to overcome the crisis. The judicial process, the police process, police manuals, CRPC, etc. Everything needs to be followed up, and every act done by the police officers has to be genuine. There are some judgments of the Supreme Court also. In fact, I tried to search it before our lecture started, but I couldn't get that citation. That particular is out of a incident. I must mention this because Supreme Court has laid a ratio, very important ratio in that judgment, that if in any offense after the conduct of the trial, accused gets acquitted and it transpires, it comes to the knowledge of the trial court that accused is getting acquitted only because of the improper investigation done by the investigation officer. I'm using the word deliberately, with a view to give a lease to that accused, with a view that this accused should get exonerated, he should get acquitted after the conclusion of the trial. If such is the case, in that case, entire matter is required to be reinvestigated, number one. And the investigation officer who had deliberately, mischievously left loopholes in the charge sheet, such officers should also be prosecuted. That is the sum and substance of the Supreme Court judgment. If I am able to get an access to it at any time after this seminar is over, I will exchange with your principal, Mr. Pradhan sir, and who in turn will share with you. It's a very important judgment, and my own desire is that every police officer, at least senior police officer in charge of a police station, should be pass on to this judgment to all his subordinate officers, that if you do any illegal act, if you do incorrect investigation, if you commit any faulty investigation, only with a sole objective, it goes quid pro quo, nobody gives does free of cost. So if it happens so resulting into acquittal of the accused, in that case, even you will be tried along with the same accused when the fresh investigation of the offense will start. And therefore, mind well, whatever you do, whatever the duties which you discharge as a police personnel, police officer, irrespective of any rank, as an IO of while investigating a particular crime or so, you have to be strictly within the four corners of the law. That is the sum and substance of the judgment. So this is all my 1 hour presentation on the crime I'm pertaining to counter. If anybody of you, because it's a very vast subject, even 3 hours will be, I mean, one might feel short. So if anybody of you is having any questions, you are most welcome to address it to me.
Thank you, sir. Thank you so much for wonderfully explaining us the concept of the law relating to police encounters. I have already requested everybody. If anyone has questions, please raise your hand. We have first our student, Mr. Menon. I'm just unmuting him. Yes, Mr. Menon.
Yeah, thank you, sir. Thank you, sir. Good afternoon, sir.
Yes, good afternoon.
Sir, as you had mentioned that now the cases of just like Dubey was killed in an encounter,
Yes.
sir, such cases are on the increase. Now, if you can see this,
yes.
Why don't the judiciary say, for example, sir, when the such criminals or alleged criminals are being escorted from one state to another, let there be a vehicle where there can be a camera or a judicial person can go along with the team, sir. Something like that, sir.
No. Judges can travel with the police party.
Not
Judges
judges,
are not
sir.
supposed to.
Okay,
what
sir.
judicial
Or
person means what?
No, some sir, responsible person, so that such things there
No.
such or
Just remember.
vehicles at
Just
or at least, sir.
remember when UP police party can for the
Yes, sir.
purpose of taking custody of Vikas Dubey, obviously they would not have left Ujjain police station or that jurisdiction of that temple, concerned police station within whose jurisdiction that temple was in existence. There must be a couple of more than 1 or 2 police stations in the Ujjain. They must have done station diary entry that we are a UP. Once, first of all, they should have reported to this police station that we from UP have come down here to take the physical custody of Vikas Dubey after learning from the media and some official wireless or some other sources, facts or whatever.
Right.
Today we are taking the custody of him. So that station diary entry must concern police station of Ujjain. So that is an admission that police party from Kanpur has taken away this Vikas Dubey with them. Now the good question is to what extent the details have been incorporated in that station diary entry. Apart from the station diary entry, whether any letters were exchanged, official communication was exchanged by UP Kanpur police with the Ujjain MP police. And obviously he was unarmed because he was arrested. If you see the moments of Vikas Dubey on the relevant day at relevant time in that temple, you don't find him with any arms, and he has crossed many barriers, many CCTV cameras, many scanners also. So if at all he was carrying any, easily noticed by those alarms.
Yes, sir.
It would firearms are immediately noticed at by unarmed fellow has been taken away from Indore to Ujjain to UP. So it was an admitted fact. Only this theory is being propounded that the vehicle turned turtle and no backside vehicles getting dashed up to this vehicle. So this is all creating suspicion. And why, if at all the road was muddy road, why only one vehicle should turn turtle? Minimum, even other vehicles should have gone haywire. एक vehicle यहाँ गई, एक इधर गई और किधर गई. It should have happened in that sense, but that didn't happen.
हाँ सर वही है सर. अगर व्हीकल में कुछ कैमरा ऐसा लगाएगा तो और थोड़ा क्लियर हो जाता है सर कि वो क्रिमिनल भागने का कोशिश कर रहा है या नहीं.
How that camera will monitor 12 hours journey plus? And who will be monitoring? They are in transit unless they are by the satellites. So that much advanced equipment, machinery we don't have as of now. That's the thing. Yeah.
Okay, sir. Thank you.
Yeah.
Sir, there is one request. Sir, can you briefly explain us two terminologies? what is transit remand and what is transit bail? You can
Yes,
just
very good.
yeah.
Yeah. Now, I'll give one instance. Now, we are in Maharashtra. Let us give the facts and figures of Maharashtra. Now, we are in Maharashtra. We are in Thane. Your college is in Thane. Yeah. Now, Mr. A is a offender. He's a accused in one particular crime that has taken place in Nagpur. He is arrested at Nagpur for a commission of crime which he has done in Nagpur. He was produced before the magistrate in Nagpur. He granted 2 days PCR. Subsequently, he has gone into judicial custody and is in Nagpur prison. But before he committed a crime in Nagpur, he's a dacoit. He's a thief. He's a robber who do nighttime robbery and all that. He had done some crime also in Nopada. So he is required also in a crime at Nopada. But once the crime is committed, throughout the state, wireless message goes the description of the accused, nature of crime, etc., etc. Possible sketch of the facial sketch of that person, depending upon the description given by, or it is noticed in CCTV camera these days and all that. So now, if once the Thane police come to know that Mr. A, who is required in our office, stands arrested in B jurisdiction and at Nagpur, then they are required to go to Nagpur jail. If they simply demand to Nagpur jail authority that give us the custody of Mr. A, who is also required in our crime, will they give it? They can't. Because he is the judicial custody of magistrate who is in the Nagpur. So, Thana police will go to Nagpur police, Nagpur court, concerned magistrate court, was there against this particular criminal. Then that concerned magistrate will be told that his presence is required at Thane. So therefore his custody be given to us. So the jail authorities in Nagpur, they should be directed to hand over this criminal from their custody into our custody, and then we will take it to Thane. If at all they are coming by road or even train also, Nagpur is almost 16 to 18 hours journey. By road it is more probable. So remand is essentially an endorsement by the court of the custody secured by the police of an accused. So when Nagpur magistrate will grant custody, they will endorse the custody to Thana police to carry that particular accused from Nagpur jail in the custody of Thane police. It will be an authorized criminal or accused in the hands of Thane police. It's authorization, endorsement. Then Thana police will travel to Thane from Nagpur. He will be produced before the Thane magistrate court, concerned Nopada magistrate court, and they will further seek his custody for the crime which is concerned with their police station, dacoity, robbery, whatever, 5 days, 7 days, 14 days, and all that. And once that custody, PCR is exhausted, is back sent to Nagpur, because from where he was picked up. This is how the concept. Somebody wants to know about the transit bail. I'll give an example like this.
Yes, sir.
Now, it does happen that in matrimonial matters, FIRs are lodged at the place where the to reside with her parents, though her matrimonial home is at Bombay. So, from Delhi getting married to a boy from Bombay, though last resided together at Bombay, but she's with her parents at Delhi, 498 and some other offences. If there is any body injury on her, 323, if she was seriously hit by any object and all, the 324, 325, 326 could be invoked. And such offences lodged at some, suppose some police station in Delhi, Karol Bagh, for instance. So that man from Mumbai is required in an offence lodged by his wife at a Karol Bagh police station in Delhi. Now, एक Mr. her husband comes to know that I stand to be arraigned as an accused in Delhi. Now he has to go to Delhi. He will be arrested. He can be arrested by Delhi police in Mumbai. So over here in Mumbai, Delhi police party is already here. Now he's ready and willing to cooperate with the police in Delhi. He does not want to be arrested. So he approaches local court over here. I mean, Sessions Court is the place where anticipatory bails are obtained. So he will just say that Delhi police, they definitely require me. I don't deny that because my name is figuring in an FIR. The offenses which are invoked are obviously non-bailable offenses. But permit me to go to Delhi, permit me to approach the Sessions Court in Delhi where I can legally apply, or subsequent to High Court I can legally apply. So just protect custody of the police that could enable me that protection, not to arrest order given to Delhi police, will enable me from traveling from Mumbai to Delhi, and that will enable me to approach Delhi Sessions Court, Delhi High Court and next Supreme Court to save myself from the arrest, which according to me is a false complaint. All allegations are false, etc., etc. So this is the case of a transit bail. Understood? Whoever has asked it. Got a concept clear now?
Yes, sir. Yes, sir. Thank you, sir.
Yeah.
Sir, one more question relating to today's topic only. The Honorable Supreme Court has, in the light of the Human Rights Commission guidelines, there was an order by the Supreme Court that involvement of National Human Rights Commission is
Yes.
not mandatory unless investigation was not done as per
Yes.
procedure. Can you
Yes.
just quickly throw some light on that, sir? What exactly?
You know, that has become a huge debate in our legal circle. The
Yes.
question arises, for what purpose the National Human Rights Commission, or for that matter, state human rights commissions are constituted? If these are not required to be taken aid of, because remember, state RC and NHRC, these are not the courts in that sense. Punitive power. Nobody is going to lay a charge sheet over there. Copy of the charge sheet can be given, but that NHRC chief man is not going to take the cognizance on the basis that will be laid before him. He will be just seeing whether any violation of human rights have taken place or not with respect to the person who is either before them as an aggrieved person, or if it is a case of death encounter, then his relations have approached and they are just disputing the manner in which the encounter has taken place. No doubt they have attempted to file criminal way also, FIR and all that. That legal recourse in criminal courts is a different thing and NHRC is different thing. So it is administrative lapses that have taken place by those officers, police personnel or public servants even for that matter, who are supposed to observe the human rights of the complainant or his relations, etc. So they are having a very limited compass or limited canvas, I should say, to the NHRC or State Human Rights Commission. Very limited. So the question is this, played in that sense, it is only a matter of inquiry that takes place. So it has very limited role to play. It does happen, it might happen that a Human Rights Commission might exonerate a police officer or the public servant for allegedly committing the violations, but same man could possibly be convicted in the criminal trial over there. Right? It could happen vice versa also. So now even a debate is started. What is the propriety of having a Human Rights Commission, which is having very, and unfortunately it is not taken seriously. It only awards a compensation to the victims or the relations of the victim if any violation of human rights has taken place from the public servant and nothing beyond that. So simply conducting an inquiry and awarding a compensation, again that compensation goes from the state exchequer, state treasury, unless the commission passes an order that money should be awarded from the monthly salary of that police officer or the government servant, then it's a different story. Otherwise, it is just apart from making an inquiry and apart from avoiding a compensation, it has very limited role to play. So I'm wondering whether after a passage of time, we might be seeing some major changes in the composition and the powers and structure of the Human Rights Commission. Efficacy of the Human Rights Commission is greatly debated these days.
Thank you, sir. And then can I ask one more last question? Is that
Yes,
okay, sir?
yes.
There is
Yes.
one question which is asked is, sir, now majority of the students here are going to represent the victim, obviously.
Yes.
So if the victim feels that the procedure has not been followed as per the guidelines, what
Yes.
remedy does the victim's family has?
Yes. Administrative remedies, they can report to the superintendent of police if the matter is coming from the districts or the commissioner of police in the city areas. That is only for the administrative grievances. And if they want, the victim's family want the justice to be done by way of taking recourse to the court, then first of all, they attempt to try to lodge an FIR against the erring public officer. If that FIR is not taken, then they can go to the learned magistrate and they can file 1563 of CRPC. Again, if they don't get a justice over there, then they'll have to go to revision court of refusal to pass any 1563 order by the learned magistrate. Then they have taken recourse to the High Court also, where they can file criminal writ petition seeking a direction to the particular police station in charge to take an offense against the concerned erring police officers. So administrative remedies there, judicial remedies also there.
Thank you, sir. And then
Yes.
one question which is very popular, I think I'm just asking because one student has asked,
Yeah.
what can be done, sir, for quick delivery of justice? It is in light of, obviously Nirbhaya case convicts and the second rape case, which obviously I don't want to name the victim here,
Yeah.
but the Hyderabad rape case.
Yes. Okay.
What can be done for quick delivery of the justice?
I mean, at the most, such matters are definitely placed before the fast track courts, number one.
Yes.
And day-to-day hearing of the matter, not more than 2 to 3 adjournments. That could be the ultimate solution.
Thank you, sir. Thank you so much for this wonderful session. If you permit, sir, can we go to the concluding part of this?
Oh, yes. You can go very well.
I am requesting our FYLLB student, Rakhi Ubare, to kindly propose the vote of thanks for today. Yes, Rakhi.
Yes, sir. Am I audible, sir?
Yes.
Oh, yes, by all means.
Good morning, everyone. Good afternoon, everyone. Today, on the 96th session of Vidhi Likhit Bhet, we are fortunate to have Advocate Ganesh Sovani, sir, for his guidance on the topic of law relating to police encounters. While we have very much heard about this topic in news and other sources, we hardly know about its nitty-gritty. I thank our guest speaker to enlighten for such an engrossing session, and I thus take the opportunity on behalf of Sharda Education Society's Anand Vishwa Gurukul College of Law to propose a vote of thanks. Thank you, sir, for taking valuable time from your busy schedule and enlightening us on this interesting topic and interacting with us so freely. I would also like to thank Dr. Pradeep Thakur, sir, Secretary, Sharda Education Society, and our Principal, Advocate Suresh Pradhan, sir, and all the member of teaching and non-teaching staff for bringing eminent speakers and introducing us to various topics and personalities for consecutive 96 days. I would also like to thank all the participants for attending the webinar. Thank you, everyone, and over to Pradhan, sir.
Thank you so much, Rakhi. Thank you so much, Advocate Sovani, sir. With this, we come to end of our session. I am now ending the session for all. The window will get closed now.
My pleasure.
Thank you so much, sir. Thank you.